Wish you all a very happy new year 2026. So, here's what happened last Tuesday. I was grabbing coffee with a friend who runs a digital marketing agency, and she said something that stopped me mid sip. I feel like we are playing a game where the rules keep changing, but nobody tells us what the new rules actually are. We were talking about GDPR and the new EU AI Act. And honestly, she's not alone in feeling that way. Today, we are going to talk about what's actually changed, what it means for how we do marketing, and whether 2026 is going to be the year everything shifts again, or it's all just the same thing in a new packaging. Let's start with where things stand right now. Starting with GDPR. It turned 7 last year and it seems that the EU isn't done tinkering with it. Maybe because the first version had very strict consent requirements, massive fines, and extensive data subject rights. Most companies are still scrambling to keep up with that version. Last year, the European Commission proposed the Omnibus Simplification Package. I often wonder why and how they come up with such tongue twisting names. Anyway, here's what it actually does it makes companies have to keep detailed records of data processing activities. There used to be some exemptions for companies under 250 employees. Now it's 750 employees, but only for companies not doing high risk stuff. What does this mean? If you're a small marketing agency handling basic email campaigns, you might get some breathing room. However, if you're using AI to profile customers or make automated decisions about who sees what ads, those exemptions don't apply. As much as these changed rules are classified as simplifications, not everyone find them so. Privacy advocates say that it's like drawing lines in different places and figuring out who gets protected. Regulations were supposed to be rights based, so everyone's data should be protected. However, with these new thresholds, they think that it's starting to feel a bit like a privilege system. On top of that, the EU just rolled out the GDPR Enforcement Rules Regulation. It doesn't rewrite GDPR, it tweaks how enforcement works when cases involve multiple countries. Basically, the EU is saying that the companies have had 7 years to get this right. Now enforcement will be consistent and predictable. What does it actually mean? Two things. First, regulators in different EU countries will work together more closely. If a company breaks GDPR in Germany and Spain at the same time, those investigations will be coordinated. Second, the involved parties can expect fewer delays, fewer mixed messages, and less room for companies to game the system. Beyond cracking down, there are new rules hitting marketers directly. Consent rules are getting tighter. This isn't theory, it's already happening. Consent now has to be clear, active, and tied to each specific use of your data. No more one and done checkboxes, and definitely no pre checked boxes. Pulling your consent should be just as easy as giving it, ideally in one click. Companies also have to record when and how they got your consent and keep those records for at least 5 years. If you're an email marketer, this really matters. You now need clear documented proof that someone said yes to getting your marketing emails. The consent has to be explicit, not implied or assumed. Cookies are going through a shakeup as well. The EU's old e privacy rules still apply, and while a new proposal was floated, it was actually dropped in Feb 2025. So the same rules stand, but regulators are going to crack down hard. So, what changes for you? Non essential cookies can't be set until someone clearly says yes. No tracking pixels without consent. Using cookie walls to block the site unless users accept everything are out. People must be able to use the core site even if they say no to tracking. Even those cookie banners will be judged closely. If you've got a big green accept all button and a tiny gray reject button, that can be seen as a dark pattern and violates GDPR. According to them, accept and reject will need equal visibility and weight. And to further complicate things, the EU is debating a switch from opt in cookies to opt out. That would mean companies could set some cookies by default. But that is allowed only if they say that they are using the data for a solid reason, it's needed to get the job done, and it won't mess with privacy or rights. And the users would have to say no. It's being considered controversial by privacy folks, and it clashes with how rules are enforced today. I wouldn't recommend building your 2026 plans around it yet, but keep an eye on this. For marketers, the core takeaway is that GDPR is not getting more lenient. Enforcement will be clearer, penalties are going to be higher, and the bar for what is considered as a valid consent is being raised. Now, let's talk about the EU AI Act. This is the world's first comprehensive AI regulation and it's getting rolled out in phases over the next 2 years. In Feb last year, the EU started banning certain AI tools. These tools included biometric systems that track people in public without consent, social scoring that rates people based on their behavior, and manipulative surveillance tactics. Then, a few months back, new rules kicked in for general purpose large language AI models like ChatGPT, Claude, and Mistral. From August 25 onwards, any new general AI system launched in EU would need to follow those rules. Models that were released before then have until August 27 to fully comply. The big deadline everyone's watching is August 2026. That's when the full compliance framework for high risk AI systems comes into effect. High risk systems include things like AI used in hiring, credit decisions, law enforcement, and critical infrastructure. Clearly, implementation of these regulations is trying to keep up with the pace at which AI is moving. In that respect, it's good. But for marketers and businesses, this creates uncertainty. If they are rolling out or planning to roll out AI powered use cases, they have little to no time to adapt. Okay, so how does all of this actually affect the work we do as marketers? Let's break it down into six broad marketing use cases. Let's first see how does this affect AI content generation. If you use AI to write marketing copy like product descriptions, social posts, or emails, the EU AI Act says you have to tell people upfront. Do it before they read or interact with the content. The rule is simple. If a reasonably informed person wouldn't immediately know it's AI made, you need to say it and say it clearly, not buried in fine print or in a tooltip. Same goes for audio and video. If you're using AI to create a podcast ad or sales video, the audience should know. There are limited exceptions for parody, satire, and some editorial contexts, but for marketing, you must disclose. This matters because human like AI content can create false trust. Disclosure helps protect that. It also affects email marketing in the way that it sits at the intersection of both the acts. GDPR still says you need clear opt in consent to send marketing emails. That part hasn't changed. But if you're using AI to write, personalize, or target those emails, you're now playing by both sets of rules. GDPR also has a purpose limitation rule. What that means is that if you collected someone's email to send their order updates, you can't turn around and use that same data to train an AI for marketing without asking again. You either need fresh consent or a solid documented reason. This could complicate things for retail marketers. These acts also impact web scraping. Some AI tools allow for scraping online profiles and using that data to hyper personalize emails. This could become illegal under the new GDPR if you are unable to establish legal reasons. The intended impact on social media campaigns seems to be huge too. The AI that picks which ads you see or boosts certain posts could be labeled high risk under the EU AI Act if it profiles people or nudges their behavior in a certain way. Then, if you're using AI for audience targeting, lookalikes, or optimizing social campaigns, you might be running a high risk system. And that means that you will require risk assessments, solid documentation, transparency for users, and possibly a human in the loop for key calls. Overall, it could make some targeting tactics off limits, or you need to justify them with thorough documentation. I'm wondering how much this would impact Meta's Andromeda or Google's PMax in the EU. If Cookie was a human, all the scrutiny that it has been subjected to would have earned it a Hollywood biopic. These acts now set tighter rules for cookies. If you use analytics that tracks individuals to build profiles, you still need consent. Simple aggregated stats that Geo4 shows, like how many visitors today, may not need consent under a proposed change, but that isn't final yet. What is final is that you need clear, granular cookie consent. Your banner should separate necessary functional analytics and marketing cookies. Let people accept some and reject others, and make it easy to withdraw consent later. And completely avoid using dark patterns. When it comes to hyper personalization, both the acts overlap in tricky ways. If you use AI to profile people, for example, guessing what they'll buy, what they'll click, or their demographics, you are handling personal data under GDPR and might be using high risk AI as per the AI Act. So you need a lawful basis under GDPR, data minimization so that you only collect what's needed to make the prediction, transparency in explaining how the profiling works, a right to explanation which allows users to ask why the AI made a call about them, and human oversight if the decision has a big impact on someone. This overlap seems to be a double compliance trap. There seems to be an effort to satisfy two sets of rules at once, and they don't always match up neatly. The impact of GDPR and the EU AI Act on search and algo driven content delivery seems to be a bit broad based. If you're using SEO tools or AI to rank and surface content, those systems could be covered by the AI Act if they are considered high risk. In that case, you'll need similar things such as clear transparency about how the algo works, solid documentation, and possibly bias testing. We now have a fair understanding of the what and the how of these acts. I think it is important to answer a question that points to at the intent behind these acts. Who is responsible for these rules? Companies or users? The answer is both, but the balance has shifted more towards companies. This is on purpose. EU rules assume most people won't read the fine print and they shouldn't need to be privacy experts just to use the internet. So the burden is on companies to make privacy easy, clear, and the default. If a user doesn't micromanage their settings, that doesn't let the company off the hook. They still have to meet GDPR and AI Act standards. Weak user habits aren't a loophole. This applies to developers too. If you're building software with personal data, bake privacy in from day one instead of slapping it on later. Privacy by design and by default isn't a nice to have, it's the law. You are also responsible for your vendors. If a third party mishandles data, you are still on the hook. So, if you're using AI tools in your marketing workflow, you need to document how they work, what data they process, and what safeguards you have in place. In a nutshell, whoever runs the system owns the responsibility. But that doesn't mean users are free to do just about anything. They need to make informed choices about consent. They need to be aware of key parts of privacy policies at least. And they need to exercise their rights when their data is misused. Now, these acts are applicable outside of the EU, which makes it complicated for businesses. If your product or service is used by people in the EU, those laws cover you whether you are in the US, Asia, India, or wherever. The location of your server or HQ doesn't matter. Whether you're handling EU residents' personal data or offering AI systems that EU customers use is what matters. And the fact that Google and Meta have paid huge fines, the enforcement is real too. So, what are the takeaways for brands and marketers? I would break them down into immediate and medium term strategies. The immediate actions that you should take include auditing your AI tools. List every platform that says it uses any form of AI, like email automation, your CRM's predictions, or social media schedulers. Ask vendors about how does their AI work? What data does it use? Have they checked it for bias? Can they prove GDPR compliance? Review consent. If you use cookie banners, test them. The reject button should be as visible as accept. Keep consent flows simple. Record consent properly. If you use GA4, make sure consent mode V2 is set up right. Build a compliance matrix. Map GDPR requirements against the AI Act for your tools. Look for any overlaps and assign owners for each task. This doc will save hours and help your legal team see what's needed. Review and tighten vendor contracts. Add clauses on AI compliance, data handling, and payment of damages if they break the rules. Coming to medium term strategies, go all in on first party data. Build your own consent based data collection and offer real value for it. Build and use assets like newsletters, exclusive content, or community access. Keep personalizing, but just make it privacy forward. Base your marketing on what people actually tell you about themselves, their interests, segments, and preferences. Use declared data, not creepy inferred behavior. It might feel like less data, but it creates stronger, more trusted relationships with customers. Be upfront about AI. If you're using it to write, personalize, or score leads, say so. Make it part of your brand story. People expect it, and transparency builds trust. Level up AI literacy across your team. Everyone should understand what AI can and can't do, where it fits, and where it doesn't. This is extremely important. Can't stress it enough. Now, before I wrap up, I would like to share a few thoughts. You must remember that these rules aren't here to punish anyone. They're a response to real problems like massive data breaches, sneaky design tricks that push people to overshare, biased AI in hiring and lending, and opaque surveillance. From a marketer's viewpoint, this is good news. When the rules are clear and shared, you win on product quality and creativity, not on who can get away with sketchy data tactics. Compliance takes time and money, sure, but ignoring it could cost a lot more. These rules are not something to be worried about. Ultimately, good marketing and privacy aren't opposites, they are partners in building greater brand transparency and trust. The future of marketing isn't less data or less AI. It's more responsibility, more transparency, and more trust by design. That's it for today. If you're dealing with any of these issues in your work, I'd love to hear your thoughts. How are you adapting to these changes? What's working? What's not? Stay subscribed and share this episode if you liked it. I'll talk to you next week.